Hi, y'all, and welcome to tonight's live stream. As promised last night, I am back with one of the wildest cross examinations of a witness I have ever seen, and I've been practicing law for 30 years. It is always wild when a defendant takes a stand, and it's always wild when an attorney takes a stand. But this is both. A defendant who is an attorney takes a stand, and fireworks absolutely does not cover it. This is a textbook example of why law schools teach lawyers that the defendant should usually not testify. It's a textbook example of why lawyers should never represent themselves. In this particular case, Robert Tellis, and I actually learned he says it Tejas, but Robert Tejas then testified as a narrative. What that means is that instead of his attorney asking him questions and he answered them, he just got up there and spoke. He had some notes and he just talked about whatever, just as he wanted to, about the various topics he had listed on the piece of paper in front of him. And that was just a narrative form. Then there was a cross-examination. Yesterday, we covered the narrative form, and that was a severe enough amount of damage to his particular case. But the cross-examination was of a completely different level. It was just absolutely wild. And I picked out for tonight some of the prime examples. I gave you one as sort of a teaser last night, and I won't repeat that one, but I've got more for tonight for us to talk about and look at as he went through it. Let's talk a little bit about what the case is. Jeff German was a reporter for the Las Vegas Review-Journal, and he was found brutally stabbed outside his home on September 3rd of 2022. Pretty much immediately, law enforcement became suspicious of a Clark County public administrator named Robert Tejas. Now, just 4 days after German was murdered, they had already arrested and charged Robert Tejas. So Tejas believed German had caused him to lose the recent election. That's what prosecutors allege. They say that even worse, German had and was exposing an affair that Tejas was having with an employee there in the office. And both he and the employee were married to other people. And as you'll hear tonight, German just would not stop. Even after Tejas lost the election, German kept writing articles about him. And the prosecution says they were terrible, embarrassing, critical, mean. If you ask Tejas, he would probably agree with all of that. And according to German, even published video, the prosecutors say, that showed Tejas and the employee getting out of the back seat of a car together. Now, he had a pretty novel explanation for that, which we won't get to tonight, unfortunately, when he did redirect. And it's just that it was a convenient place for a meeting and quiet. German, or something to that effect. That's not an exact quote. That was my impression. Now, German also wrote stories about a lawsuit against Tejas or about the allegations that then later became a lawsuit against Tejas, that he was making advances toward young female employees, retaliating against women in the office, etc. So bad blood between them is not strong enough. It was extreme. And we are going to get into what happened on cross-examination because it's wild. You absolutely have to see this. So a special shout out to the first 5 in the chat tonight: Annalise, Janet, S. Cipher, Misconstrue, and then it was a tie between Denise Pelton and Mel Stiller. All right, so let us go ahead and start off with the Robert Tejas cross-examination. One of the things, and I want to talk for just a minute about what the prosecutor does here, because it's a pretty harsh and mean sort of cross-examination, and you can't do that every time or with every witness, because a jury will get turned off by that. The jury will be upset that you were so mean to the witness. You have to be very cautious about when you use that. Notice how hard he goes at Tejas. It's super hard. It's no holds barred. It's just, gloves are off. everything you can imagine. And in this particular segment, you're going to see he actually makes fun of him in how bad a job he did of the killing, according to the prosecution. Now, why was he able to go that hard against him? We're going to talk about that after we listen to this first little section.
Watch this footage. Isn't it true that we see the killer come back to the scene?
Yes.
And the killer seems to be looking around as if he forgot something, right?
I've watched the video. I don't know what he's doing.
We don't know.
Right.
But we know a professional killer killed someone in broad daylight, made it a point to park on a completely different street, but then for some reason decided, oops, I forgot something, and drove all the way back.
My belief is that he wanted to make sure to commit the crime, and then when he was done, he wanted to make sure the SUV was seen in front of the house.
So let me get this straight. We've watched the footage, right, Mr. Tellis?
Yes, sir.
Isn't it true that the Yukon parks on Wintergreen initially?
I'm sorry, I wasn't paying attention to the streets, but I mean, if you say so, yes.
We'll put it to you this way. He didn't park on Bronze Circle, did he?
Not initially, no.
And by your logic, if the killer wanted to be seen, shouldn't he have just parked on Bronze Circle originally?
I would have thought that, if he wanted to make sure he got the job done first, that he would not have actually parked the SUV in front to begin with.
Oh, so
that's my belief, because,
okay.
Again, that isn't me.
So you have a killer who goes all the way out of his way to park on a completely different street, walks the whole length, does the killing, drives out of the complex, and then makes a U-turn, comes all the way back into the complex, pulls up, gets out, looks around for something, and you believe that's all part of the assassin's plan?
And again, I don't know what he's doing in that video.
No, I'm just using your words, your thought process.
Absolutely.
You believe that was all part of the plan?
I do. It wasn't me, so.
Sir, doesn't that look a little amateurish?
I would like to think that I wouldn't use my own car if I was actually the person who did this.
Well,
Okay, I'm going to stop it right there for just a minute. I want you to listen as we do this for all the times that he says something along this type of language. It's not normal. I would like to think that I wouldn't use my own car if I was actually the person who did this. That's what he says. I want you to just note that language, think about it, and we'll come back to that. Remind me if I forget some of these things I keep saying I'm going to come back to.
doesn't it look a little amateurish to take the steps to park on the side of the street, then you forget what you dropped, probably your murder weapon, who knows, wear this goofy sun hat, a bright orange shirt. I mean, you really think that looks like a professional killer?
I do. Again,
Okay.
It wasn't me, so
Okay.
yes.
All right, sir. And when you looked at the car, you thought, gosh, that looks just like my vehicle, right?
Except for the rims, yes, sir.
Okay, so, and let me make this a little bit larger. But all right, so what you see here is a prosecutor going no holds barred right against Robert Tejas. And you even the, I get it now kind of approach. Well, the reason he can do that, I think, is because he believes the jury is already turned off Robert Tejas. Now, you can't do this often. You can't do this with many witnesses in the course of a trial. If you can't even do it with one, that's a lot. And in this particular case, the prosecutor has made the decision that the jury is already turned off Robert Tejas, and it's okay to go all in, no holds barred, straight against him. And that's what he does. And it's a pretty brutal, harsh cross-examination. First of all, I want to say thank you to Mama Pinks, who is of the opinion that he is really making a lot of mistakes. And MT Kaysen has the same opinion, that it was the worst act of self-destruction I've ever seen by a defendant on the stand. I have to agree. I mean, I guess he could have admitted it. Other than that, Perry Mason style, maybe he would have admitted it, but it's astonishing. He did, in fact, do himself a lot of harm. I agree with that. And welcome, Melody Perkins, who's a new member. All right, so let's take a look now at what the prosecutor moves into about the DNA evidence. He says, because Tejas has an explanation for everything. I talked about that last night, and I talked about the fact that one of the big red flags for me, if a potential client comes is I don't want somebody who has an explanation for everything or who has been wronged by anybody and everybody. And Tejas fits both of those categories here. Now, he is going to talk about some pretty astonishing DNA evidence in the case, because the DNA evidence showed that the victim, Gurman, had DNA from Tejas under his fingernails. Now, the prosecutor is going to say, how's that going to happen if you had nothing to do with the killing? How does that even happen? You hated him. You weren't friends. So let's hear that unfold.
You're not disputing that your DNA is underneath Mr. Gehrman's fingernails, are you?
Yes, I am.
Okay. But you've heard the testimony. It's there, correct?
I don't know if it was there or at what point it might have gotten there, sir.
Okay. I'm not asking you how it got there. Are you really denying that your DNA is underneath the fingernails?
Without knowing the truth, yes, I am.
Okay. Well, you've heard witnesses testify.
Right.
So the DNA lab's in on it too?
I don't know. I don't know at what point. I don't know what point this sample was collected.
Sir, please tell this jury, how in the world does your DNA get underneath Mr. Gehrman's fingernails?
I don't know because I did not kill Mr. Gurman.
You have no idea how it could have gotten underneath your fingernails, correct?
Under my fingernails?
I'm sorry, under his fingernails, correct?
I don't know that it ever was, sir.
All right. Let's do it another way. You and Mr. Gehrman are not friends, are you?
No.
Okay. You don't hang out with him ever?
Sir, I did not ever hang out with Mr. Gurman when he was alive.
My question is yes. You didn't hang out with him ever, correct?
I did not.
He's never invited you over to his house.
No, sir.
You've never hung out, had drinks at a bar, correct?
No, sir.
There would be really no opportunity for him ever to put his hands on you in any sort of social situation, correct?
Correct, sir.
And yet, these two people who are not friends, your DNA just happens to be underneath his fingernails. Correct?
No, sir.
Okay. You just don't think it was legitimately placed there, correct? Or are you just ignoring the testimony of all of the witnesses that talked about how your DNA was underneath the fingernails?
Again, at some point or another, I believe it was planted because I did not kill Mr. Gurman.
So this testimony is saying that he actually believes the evidence was planted. Could it possibly have been that someone actually planted it under the fingernails of Gurman? Or was it maybe that someone just mixed his DNA with what was found underneath the fingernails? That's what he's arguing. He's arguing that this was all a setup, that what actually happened here is a vast conspiracy by many, many people in law enforcement and elsewhere. And the prosecution is going to make good use of that. The prosecution is going to say, how many people could possibly be involved in this? And here's another, and each time we'll point out how someone else might be involved. Now, one of the best pieces of cross-examination for the entire cross-examination related to the shoe under the couch. I thought it was really, really well done. To give you a little background, there were distinctive shoes that the killer was wearing. They were Nike shoes. They had stripes and so forth. And so they were fairly distinctive. And a chopped up one of those shoes was found under the couch at Tejas' home when he was arrested. So while he was at the station, they were executing a search warrant in his home, and they found this cut up, chopped up shoe underneath his couch. And they also found a hat, a bizarre looking, large, enormous brim hat that the killer was wearing. They found a similar one chopped up in a trash can in Tejas' garage. So if it was a setup, it was a very, very thorough one. That's the point the prosecution is going to make. They planted identical evidence to what the killer had worn, and they did that inside his house. And they even planted things that were exactly like items that he really had, because he really did have shoes that looked just like that. Here is where it gets really hard for the defense.
That's your couch, right?
That is my couch.
And underneath your couch is a shoe and a chopped up shoe, right?
Right.
Okay. That's the gray Nike, correct?
Pure so, yes, sir.
Publishing 228. That's what it looks like, correct?
Yes, sir.
It's gray in color, correct?
Yes.
It is a Nike brand, correct?
Yes, sir.
It has a black swoosh, correct?
Yes, sir.
It has 4 horizontal, or at least vertical bars in the middle of that shoe, correct?
Yes, sir.
All right. You would agree with me. That's the shoe that the killer was wearing, correct?
I don't know that that's the case.
You don't know, well, it sure looks a heck of a lot like it, right?
Yes, it could be the same model, but it could be a different size.
Sure. Let's just look at it. I mean,
I don't disagree that it's the same model.
right. It's the exact same type of shoe, right?
Right.
Okay. So we're not in dispute about that. We can agree on that, right?
Right, yes, sir.
And your DNA is in those shoes that are found in your house, correct?
I don't know that to be the case.
Okay, but
I don't
that's
know why
the
it
whole
did
thing of like.
it
it's
did
a
that
setup
on the
and
real
I think
broadcast.
The DNA people are framing me, something along those lines, right?
Whether it's them or someone else?
You've
Sure.
heard the results. The results say that your DNA is in that shoe. I mean, we did hear that, correct?
That is what we heard.
Okay, and you just think it's just another part of the conspiracy to somehow get your DNA into those shoes.
So I believe that there are officers who, when they think that a fellow officer needs help plugging holes in the case, that they're willing to do what they have to.
So this becomes more and more for the jury to swallow. Every time he adds a new piece to the conspiracy, a new person to the conspiracy, a new agency to the conspiracy, it makes it more and more difficult for the jury to swallow this. It gets bigger, more and more enormous. So everything the killers, the people framing him had thought of, from DNA under the fingernails to DNA inside the shoes that were then planted under his couch at his home, and that happened to be exactly like shoes he had that were actually shown in pictures he'd taken under other circumstances. So let's continue with this line. It was really well done.
Here's the thing. Are the shoes underneath the sofa of your house, are those actually your shoes?
That I don't know for sure. I do have similar ones.
It's the same shoe, isn't it?
It is potentially the same shoe as the one, yes.
Well, sir, you're not doubting that this is a photograph of shoes that belong to you, correct?
Right.
Okay.
This is me.
So this wasn't planted evidence, right?
The picture of the shoe, no.
Okay, great. And you were claiming ownership over that shoe, right?
Right.
So it's gray in color, right? It's got the black Nike swoosh, correct?
Right.
It's got the 4 black horizontal bars in it, right?
Right.
And you would agree with me, when you wore those shoes, you probably left your DNA behind there in those shoes, right?
Yes, sir.
And you're saying now that it's just a pure coincidence that the exact same type of shoe sitting underneath your couch in your house with your DNA on it, that's not the shoe?
Remember that I was under surveillance by Detective Jappy, and this was on a day that I was under surveillance.
Let's get back to my question, sir.
Yeah.
You're trying to tell me that the shoe that you see in that photograph, that you claim ownership on, that you say you put your DNA in, that looks identical to the shoe that's underneath your sofa, underneath the recliner, you're saying those two are not the same shoes?
I don't know that they are.
Okay. It's just another crazy coincidence, right?
When somebody chops up a shoe and puts it under the couch, that's a little strange.
So there's something everyone can agree on. That is indeed a little strange. Chopping up a shoe, putting it under your couch, just strange. So to kind of shortcut this and cut out a little bit, essentially what Tejas argues here is that they figured out either, and he won't pin down, it could have been during the surveillance or it could have been beforehand. The conspirators who framed him figured out that he had a pair of shoes like this. And then they used those shoes to frame him. So that was how they selected it. So he's going to say that they found out about it. I found out about it on surveillance after the fact, and the prosecutor's going to ask more about, well, okay, how did the killer know to wear those shoes? Anyway, you're going to hear it.
You believe because you were under surveillance, what? That they knew the type of shoes you were wearing?
Yes, sir.
Okay. You've seen the photos from the surveillances, right?
I have seen some of the photos from some of them. Not everything was produced to me.
You're not wearing the Nikes.
Not everything was produced to me, sir.
Yeah, but
So he argues that maybe they didn't produce the pictures to him that show that he wore those very shoes during the course of the surveillance, but the surveillance didn't happen until after he had actually become a suspect in the murder. So how did they know for the killer to wear those shoes? It remained sort of unexplained. Throughout this, the conspiracy against him grew larger and larger and larger. And here's another example of that. Now, one of the entities he believes was behind it is a company called Compass Realty. And he and Compass Realty had a longstanding dispute. He believed Compass Realty had been given special privileges from the county that they shouldn't have been given. And he was trying to take those away. And obviously, they disagreed with that. And they definitely were opposed to him. And he says they were behind all of this, that they were committing fraud against the county. And they were behind this conspiracy to frame him for murder.
Okay. Of what was produced to you, which was everything,
It was not.
you're not wearing the Nikes on the days that you're surveilled. Isn't that right? If Compass Realty
Here we go.
framed you, how in the world would they know about these shoes?
Again, I said that I was under surveillance by Metro on this date, 8/19, and obviously they took photos
Uh-huh.
and they provided those to Detective Jappy.
Okay.
So
So what? And then Jappy did what with them?
pass them to whomever he needed to. Again, I didn't commit the murder, so
Okay. So, sir, there's no way Compass Realty could know you had shoes like that.
they're
Correct?
not without being informed.
Okay. And this phone and this data about your phone isn't produced until after you're arrested, correct? Therefore, the only way anyone could learn about information inside your phone would have to be after the murder was committed, correct?
No, sir.
Okay. You think there's a way that someone could have found the contents of your phone prior to the murder?
We heard earlier about the fact that someone can actually hack phones, yes. And whether it was that they found it that way or by surveillance,
We heard about the hack. It was just a question asked by your attorney. No witness ever testified that your phone was hacked, correct?
but you asked if there was only one means, and
Okay.
no, there's more than one means.
The Las Vegas
So
Metropolitan.
now the prosecutor is going to start into a series of questions, sort of things that make you go, kind of questions. And they are really good, hard-hitting questions. And you're going to watch Tejas attempt to answer them, give his best explanation for each of these. So the very first one, right off the bat, if Tejas committed the murder, then why not frame him with the murder weapon? After all, the conspirators would have had the murder weapon. They were the ones who actually committed the murder. Why not frame him with the shirt, that orange jacket he was wearing?
Police Department wanted to frame you. Why didn't they put the murder weapon in your house?
I think that maybe, I don't know. I mean, it's a good question. I mean,
Great question, because if the murder weapon that had Gehrman's DNA in was inside your house, wouldn't that be an even better case?
yeah, but at the same time, I think if,
But it's not there, is it?
no,
No, it's not. Even though, according to you, they control everything, they don't put the murder weapon on you? Does
Well-
that make any sense?
I think it does.
Okay. How about this? If Compass Realty wants to kill you, why don't they encourage Metro like, we'd really like you to put the murder weapon in there? Why didn't they do something like that?
I don't know.
That seems really odd that the most significant thing is not in your house, correct?
I think what's odd is that 5 days after the murder, that supposedly there was a shoe
So the answer
and
to my
also a
question-
hat in my house.
So the answer to my question, the most significant piece of evidence, the murder weapon, is not in your house despite your theory you've been framed.
That's correct, sir.
We've seen the picture of the killer. What's the most notable thing, by far the most notable thing on the killer's person?
It's either the hat or the shirt.
It's the shirt, right? And that shirt is not in your house, is it?
No.
If Metro or Compass or Rita or Cliff all wanted to frame you, why didn't they put the bright orange coat in your house?
I couldn't speak to that. All I can tell
Doesn't
you is,
that sound not very professional if they're trying to set you up?
I don't know, maybe for plausibility's sake, they put half the
Oh,
stuff
they
in
want to
there. I'm
dial
not
it
sure.
back.
I don't know.
There's
Okay, so Additionally, one of the pieces of evidence against Tejas was over 100 images of the neighborhood where Gurman lived. That the victim's neighborhood had the photographs of those being on his phone. The prosecution says that's because he was scouting out the area, plotting the murder of Gurman. He, though, believes those were planted as well. Here's his explanation.
There's over 100 images of Bronze Circle neighborhood in your house, correct? In your phone, isn't that right?
I don't know that they are, sir.
Okay, well then let's start clicking.
Plus, again, I wouldn't use my card. It's
not my question. My question is, this is contained in your phone, right, sir?
I don't believe so.
Okay, you don't believe so?
If it is in there, I didn't put it there, sir.
Okay, so the answer is it's there, but you didn't put it there, correct?
Again, I do not know that it's there, and I certainly did not put it there.
Okay, so we're just... Okay, sir. You did.
You're asking me to testify something that I can't tell you is true.
Right.
Okay, so once again, they're pointing out, the prosecutor then goes on to point out, I should say, that nobody else in the trial has testified that there was something wrong with the phone, that there was something wrong that would have caused his phone to receive these images or something like that, some kind of virus where they were being planted on his phone. So the next question, the make you go, question is, why not just wait until the new person took office? It was just 3 months away. Another person had been elected. Tejas had not just lost the election, but come in third, and he believed because of the articles written by Gurman. So things were looking up. The people who supposedly were framing him had supported financially the person running against him who won and came in first. And she's about to become the new official. Why wouldn't they just wait? And here's his answer.
Sir, you were a lame duck as of September 2nd, 2022. Isn't that right?
But I still continue to fight Compass Realty.
That's not my question. You're out of a job in that you're not an impediment as of January 1st. Isn't that right?
As of January 1st, but I was right then.
So you're trying to tell us that Compass Realty was so upset with you that they backed a candidate who wins, but then they just can't wait any longer, so they murder a reporter? They can't wait the 3 months?
I would recommend that the jury watch the video and again see the time at which the order was filed, and I think you might agree that yes, that is absolutely the case, sir.
So the answer to my question is yes.
That
Compass Realty, even though they successfully backed a candidate that defeated you in a primary, they couldn't wait another 3 months for you to leave office, correct?
Because I've got the authority to really crack things open then.
So his argument is, even though he was going to be out of office, he still had a certain number of months to be working, and he was going to be working hard against the people who were framing him. So they had to spring into action immediately to discredit him and to keep him away from what was going to harm their business. So that's the argument that he makes. Now, the next question, I'm just going to let the prosecutor ask it and you'll hear.
And if they hated you so much, why didn't they just kill you?
That's a really good question, and I would like to answer it. My belief as to why they did.
Please tell me why they didn't just bother killing you.
Because if they'd killed me, would that have stopped Nevada State Division from investigating them? No. If they killed me, would anybody have felt the duty to continue my work because I was actually doing this? I think so. So murdering me would have not discredited me. It would not have put me in a position where all the work that I was doing just got left by the wayside. It would make no sense to kill me.
So your theory is that Jeff Gehrman is collateral damage?
When you've taken into account the fact that months earlier we had this public feud, it's a pretty convenient way to do this.
So the guy who writes the articles that ends your career, they reward him by killing him?
Well, again, like I said, it was a pretty good way to do this.
So one thing that just amazes me is how incredibly calm he is through all of this. It seems to me like I would be really stressed, really tense in this situation, whether telling the truth or not. It seems like you would pretty much be very tense, but he is unbelievably calm through all of this and has, as I said earlier, an answer for absolutely everything, even an explanation for why they didn't kill him, because they felt like if they killed him, it was only going to springboard the investigation against them. They had to do something to make him look bad. That was their very best way of getting away with the fraud they were committing against the county. That was his argument. So, and the fifth question that I mentioned, how exactly did this all take place?
So, how did Compass break into your home to plant this evidence?
Like I said before, I don't know how it got in there, but I did not put it there, sir.
How did they plant the hat?
Again, I don't know how it got there, but I didn't put it there.
How did they plant the shoes?
I don't know how it got under the couch, but I did not put it there.
How did they get your DNA in there?
Again, I don't know when and where that DNA was allegedly obtained, so I couldn't say, sir.
How did they put the images in your phone?
Again, I don't know if that was in my phone or on a corrupt image or what have you.
Please.
So, to be fair, he did not have an answer for everything. So I overspoke when I said he had an answer to everything. As he goes through this, though, it really reminds the jury, the prosecutor has done a good job of pulling out all of the pieces of evidence that he believes were planted, and to make the jury think about what would it take for that to happen? What would it take for the DNA to be under the fingernails, or at least for someone to fill out a report saying that it was? What would it take to get the shoes under the couch? What would it take to, and they go through the list of things to just sort of make the jury think, okay, if someone went to all of this trouble, this is an awfully hard number of things to explain. It becomes really difficult for that to happen. Now, the prosecution ended with a bombshell that pretty clearly was not expected by the defense, that possibly there was a deleted text message from his wife saying, "Where are you?" One of Teus's arguments had been that she wrote him and that he was at home. He went for a walk. When she wrote him, he didn't respond back to her because he was about to be home. There was a text message that was deleted that said, "Where are you?" That was, according to the prosecutor, exactly during the period when he was allegedly at the scene committing the murder. Now, here is how that
read to this jury.
went out. What
does it say underneath that photograph?
It says, "Where are you?"
Where are you? You told us you were at home.
I did not. I said, actually, when I got the messages, I was still on my walk.
Sir, is it your testimony that you were at home on the day in that morning?
Not the entire morning, no. And
Okay.
I said that to you,
And
sir.
let me ask you this question. That message isn't on your phone, is it?
It isn't. I mean,
The answer
if
is no.
it was
It's not
sent,
on your-
if
it's
it
not
was
on
sent,
your
it
phone.
should have been.
One
But
at a time, one at a
Sir?
time, please.
Yes or no? That message isn't on your phone.
why it isn't, I wouldn't know, because
I didn't
apparently it's
ask
not.
you why.
It's not on my wife's phone either.
Sir, I didn't ask you why. I asked you a yes or no question. That message is not on your phone, correct?
From what you showed me, it is not.
And she's asking, where are you? Right?
Yes.
At that same time, at 10:30 in the morning, we've seen video surveillance of a car that you say looks just like mine driving in Mr. Gehrman's neighborhood, correct?
That is correct.
So that was the bombshell that they ended with, that it looked like there had been a text message between the two of them, between Teus and his wife, saying, where she wrote and said, "Where are you?" right during the exact period, and that it had been deleted from both phones. The implication being that it would have had to have been deleted by Teus. Now, where we are with the case currently is it's all wrapped up except for closing arguments. Jury instructions and closing arguments will take place Monday morning, and the jury will be out to deliberate and to make a decision in the case about what it wants to do with the charges against Robert Teus. So if you've got some questions, go ahead and put those in the chat. If you would put question marks at the beginning, it'll help me spot your question more easily. So as we do that, I want to say a couple of things, because one of the things we talked about yesterday was the fact that he made a comment about being 6'5", and it was very confusing because it was in the context of putting lifts in his shoes. And we thought, okay, why would a person who's 6'5" put lifts in their shoes? What, are you just trying to dunk on everybody? You're already taller than anybody else and you wear lifts? It just seems wrong. But as I understand it, and he answered today, how tall are you? And he said he was 5'5". So that was a difference. Another thing I wanted to point out, that little clip of video of the person walking, wearing the enormous broad brim hat and the orange jacket. The person has a slight limp, and apparently Tejas does it well. That was another way that the prosecution connected him. Now, we saw a few examples tonight, but more yesterday in what we did. And there's some more from the redirect, it's not really redirect, re-narrative, I guess we call it, that he does later in the day today. And during that period, he uses a lot of that language I told you about. I would like to think I would have driven a different car. I would like to think I would have. And it almost sounds as if he's had all this time, because apparently he's been in prison this whole time, or jail, that he's had time to think, boy, sure do wish I'd done this or that. I would like to think I would have driven a different car. Why didn't I do that? And that it came out more like that than he intended it to, I think. I don't think he intended that. I think he intended it to be sort of a way of musing together with the jury about how no one would ever do this. Obviously, he would not have done this. Okay, Mark Chandler asked me, when there is overwhelming evidence, can a jury request early deliberations? And no, they can't, because the jury is supposed to hear all of the evidence 100% before they begin to deliberate. By the way, there were two questions that the jury asked. I had those for you. Let me see where they are. Here we go. The jury in this particular case is allowed to ask questions of witnesses afterwards. And they had two questions for Tejas. Super interesting. The first was, did your wife find out about your affair before Gurman's murder or after Gurman's murder? And that was a fascinating question. What he answered was that she found out before Gurman was murdered. The sort of implication was maybe he was killing Gurman to keep his wife from finding out about the affair. But he claims she knew about it, and she knew about it in advance. Another juror asked him, how tall are you without lifts? And that's where we got the answer. He said he was 5'6.5". So he was definitely not 6'5", as we heard yesterday. There was also just a moment when he started to introduce something about Paris Hilton, and the judge cut it off as irrelevant, which it clearly was, but it did sound like it was about to be entertaining. We never did find out what that was about. All right, so looking for the question marks at the beginning. Who does the defense argument? I don't know the name of the attorney, but the closing argument will be done by the same attorney who has been representing him, or attorneys who have been representing him. It will not be in the narrative form. That was solely for the purpose of his testimony. And I talked last night about my guess about why that would be. It's just a theory. We obviously can't get right in the middle of that relationship to know why the attorney and the client changed things up and the client gave a narrative. But there is a comment, this starts to get sort of esoteric, but I looked up the rule, because there are rules that attorneys have to follow, rules of professional conduct that talk about the attorney having a duty of candor to the tribunal. What that means is you can't lie to the court, in short. And in this particular case, there is a conflict, perhaps, because you've got every state has those rules, but you've got a defendant who has the right constitutionally to take the stand, to testify in his own behalf if he wants to, but you've also got the attorney who doesn't want to violate his duty of candor to the tribunal. And as I comment to the American Bar Association model rules, it says in some states, the way that is worked is the attorney puts the client on the stand and the client uses a narrative form. So is that possibly why? It doesn't seem to be a requirement in Nevada, but it definitely is a possibility. At least it seemed to me, based on the way the rule was written, that it theoretically could have been. All right. Couldn't they just verify that his car wasn't at the home via his wife? I don't know if she didn't know or if she wouldn't answer that. I assume that they don't have that testimony available. She also might have marital privilege that would cover some of their conversations. And I don't know exactly where all that fell out. Maria Z. Maria Z wants me to take over his defense and set him straight. I don't know. I think this would be a hard one. I think I'm going to leave that to his attorney. This is a hard case. I'm going to put it that way. Daniel Corbel, was he assessed by a shrink? He is showing signs of disorder. There doesn't appear to be any attempt to argue that. I haven't seen anything about it. And he's extremely intelligent. So I don't think that there's an argument that he lacks the capacity to stand trial. So as far as I know, there's been no suggestion related to that of any kind of mental health issue. Melissa Moondrops Burst wants to know, Melissa, I did just answer that question. That is what I think. And let me go ahead and take a look at, I want to read the exact thing from the rule to you, because I think that's probably what happened, but I do think it's important. So I'm looking for that real quickly. We'll tell you what, while I look for that, I'll answer another question, which of course is impossible, right? I can't do both, but let me go ahead and flip over. But the general idea is, in some states, the defense attorney has to put the person on the stand, and one way you might do it is a narrative. It doesn't seem to be necessarily from this state, but it seemed like maybe they were trying to use that format. Next Gen asked about phone pings and whether they mapped them to the neighborhood pics. I believe that on the day of, he didn't have his phone with him. That was one of the things they were arguing, is that he answered text messages promptly, phone calls up until a certain amount of time. Then there was a big gap, and then he started over again. Also, I believe that location data was removed from his phone for an entire month, the month of August. And I believe that, again, the prosecution believes was done intentionally to keep them from tracking him. Gene asking me, what is his lawyer telling him? He can't have agreed with this. You know, it's been reported widely that his lawyer did not agree with him testifying. I don't know exactly what the basis for that is, other than the complete despair that the lawyer seemed to be in at the table. He was just kind of, okay, well, I'm just waiting for my turn while Rome burns around me. You know, it was just really a difficult cross-examination. And a difficult direct examination or narrative. It was really tough for everyone. All right. Can't they call his wife to answer questions? Probably not, since they're still married. Derek Morris, is Taya still wearing a paper suit because he knows he's doomed? I don't think so, but it is, I think, a common thing that there are precautions taken against unaliving following a verdict, if that happened, but there hasn't been a verdict, so I don't think that would happen yet. Laurie Marie, has his wife appeared in court? I heard that his wife was present, but I don't know what she looks like. So I haven't seen her. I don't know whether that's true or not. I just heard people talking about it. Melissa asking, why is Tejas allowed to speculate just because there are no objections? Pretty much, whenever there was an objection, just about, it got sustained. The judge pretty commonly said, yeah, that's hearsay or whatever. And she stopped him. But I think that the prosecutor knew that it was a really good idea to let him talk, to give himself a rope and let him hang himself, as the expression goes, that was the very best thing that could be done. So Rue is speculating about what kind of shoes those were, and they were Nikes because we know they had a swish. So that's all we know about them. And I do not know anything more than that, but thank you very much for the super chat. Sky Goddess, glad you are enjoying the chat. We have the world's best chat. Love our chat and really appreciate our moderators, Marlon and Mama Pinks, who keep it happy and light and keep everybody being super nice to each other. And I give y'all so much credit for that. There are a lot of places on the internet where there are people who are just mean. And that doesn't happen. I think y'all come with a very respectful attitude, wanting to learn from one another. It's really refreshing to see. Thank you for doing that. And A Busby, thank you for the super sticker. I appreciate it. Okay, headed back over for more questions. Afton Farid. Now, I see somebody saying that they love the KS. I love the jurors' questions. Me too. I thought their questions were very, very insightful. And there was one they asked somebody later in the day that even suggested they were thinking through the whole and I didn't have time to do those last two witnesses, but they were thinking through the whole allegation that this was a conspiracy. Somebody asked, could there have been an airdrop of the photographs to his phone? In other words, maybe it wasn't really, he didn't take the photographs. Maybe somebody put them on there using airdrop. And the witness pointed out, well, the problem with that is this is a Google phone and airdrop is an Apple function. That doesn't necessarily mean there's not some equivalent of that from Google, though, some way to put the pictures on there. It does suggest that one of the jurors at least is thinking seriously about the idea that there was a conspiracy. It could be that they actually believe there was a conspiracy, or might have been, or it could be that they're preparing to combat people who might believe that they're preparing their very best arguments to try to persuade the others. It's hard to know that obviously in advance. Okay, Afton asking, could the prosecutor have impeached him on the claim he's never beaten anyone up? I don't know anything about a prior DV arrest, so I can't answer that. I don't know. But he may have opened the door with that. They may have been unprepared for that, and they may have felt like introducing that could add a possible appellate issue, and they just decided to stay away from it. That was probably pretty wise. All right, looking for question marks at the beginning, which is my only hope of spotting these in here. Rochelle asking me, what wouldn't it take if millionaires and millions of dollars were illegally being made on a regular basis and he wanted to legally stop it? And that is his argument, Rochelle, is that there are people who stood to lose a lot of money, and they stood to lose a lot of money because he was investigating and trying to point out fraud that was going on right under the noses of the people there in the county, and they were losing a lot of money. And as a result, they needed to put a stop to it, and that he was pursuing it when others would not. And that may well be the case. It may really truly be that he was doing good work in that role. So, but obviously a completely separate issue from whether he became angry enough at Gurman to murder him. But those are definitely that would be the motive. And I think you have nailed exactly what he is arguing, what his side is arguing. Bob asking about the Paris Hilton reference. I'm trying to remember exactly what it had to do with, but it had something to do with whether or not somebody from the sheriff's office, he started to get into a story about why the sheriff had done something that could embarrass him or something that had to do with Paris Hilton. Like, please tell us, but we got nothing on that. So I don't know what it was about. Becky Ireland, do you think he's so calm because he's convinced that he's doing such a great job on the stand? Maybe that's exactly what it is. Maybe he thinks, okay, this is going great and I'm being very successful in persuading the jury. Maybe, and he can see them and we can't. So who knows? That's certain. It could be his view that he's really successfully doing this. All right. So Patricia, why didn't he throw away the shoes and the hat and the orange and the orange jacket? Why? Sorry, let me rephrase that. Patricia asking me, why didn't he throw away the shoes and the hat? And was the orange jacket ever found? I think no on the orange jacket. And by the way, no on the knife, the murder weapon. Those two were both permanently gone and not found and not offered in evidence. But the shoes and the hat were both cut up and found there. And why on earth he would keep those, I don't know. I mean, that's part of his argument. Why would I do that? Why would anyone keep those lying around the house if they were so tied to the investigation? Now, the prosecutor tried to make a point that the hat was less important than the orange jacket. The two things he got rid of, this is the prosecutor's theory, were the knife and the jacket, because those were the two things that would be a direct tie. And that was why he got rid of those. So that's what they're arguing. And he's arguing that he can't explain why those weren't used to frame him. There was maybe enough evidence otherwise. So let's see, looking for question marks at the beginning. Angelique asked about penalty, and I'm not sure exactly what it would be. I'm assuming it would be life in prison. S. Cipher, how can his attorney keep representing him? Well, under that American Bar Association comment, the way it works is that the attorney doesn't participate in testimony that he believes would offend his duty of candor to the tribunal, telling the tribunal the truth, but he doesn't participate in it, but he can put a defendant on the stand if the state law says so. That's what the American Bar Association rule comment says. And so it seemed as if they were sort of invoking that process by the fact that he said, yes, I talked to the prosecutor and I cleared this with the judge, and now he's going to do a narrative testimony. And he just stepped back. Tejas went to the stand, took a set of notes, and then talked to the jury just off the cuff. It definitely changed things because normally an attorney might put some brakes on either side, kind of guardrails to keep a witness within certain sort of parameters, to keep the testimony right on target with what was important and what was asked and what the jury should hear. And often it rambled, and often it went into areas that the jury might offend the jury, that the defendant probably would prefer in hindsight that they not be talked about. What was his explanation for his cut finger? Angel asked. So the explanation, as I understand it, was that he was preparing chicken fried rice for his daughter and cut his finger with a knife while preparing that. And he also said he looked up the recipe. So there was testimony toward the end of the day where one of the witnesses said that he had looked on the computer and there were plenty of searches for recipes, but no searches for chicken fried rice. And that was, I think, an attempt to discredit his claim that he had been making this dish for his daughter. He said it was something like 2 days after the murder that he cut his finger, and that's why when he was arrested, he had a cut finger. All right. Thank you, Olga, asking about my hair. I appreciate that. I don't have any answers, just luck, I guess. All right. Annie K, if Tejas is convicted, will his being an attorney damage any appeal claims given his own mistakes? Well, the fact that he took the stand would have hurt him in any situation with appeal. The fact that he's an attorney taking the stand means he can't claim that he didn't understand exactly what was going on. The judge even said something to that effect. Well, you know what you're doing here. You understand the consequences, and let him get on the stand and talk. And that's what he did. So there might be other issues that wouldn't be affected by the fact that he's an attorney. An example might be some hearsay, say, that was admitted, or a witness who was allowed to testify who shouldn't have been. That would have nothing to do with him being an attorney, but his choice to testify, that will probably be something he'll just be completely bound by. Just about any defendant would be, because the judge is going to go through with them. Do you understand? You know what you're doing, and you don't have to do this, and you're choosing to do this. So in most cases, if a defendant takes the stand, that there's not going to be any second guessing of that. Definitely the case here. Sally asking, and this is a good point. The fact that Tejas is an attorney, would that open the door to a more aggressive cross-examination? It was an extremely aggressive cross-examination. Probably the fact that he is an attorney would make it a little easier for the prosecutor, but I do believe that the prosecutor made a calculated choice, that he thought the jury was already upset with him after his narrative, and that the jury would be accepting of him being this hard against Tejas. If he had been an attorney who had been very appealing, the jury had really seemed to connect with him and understand him, I don't know that it would have been appropriate, or he could have gone this hard in the cross-examination without running the risk of offending the jury. Oh, I have 2 more people over here. Shy Gal believes he is not very good at reading a room. Well, that could be the case, because that could be the case. I try to always pay attention to what people say in the chat wherever I'm watching. And wow, it was overwhelming that people felt like Tejas was guilty, that they felt like Tejas did a poor job on the testimony. I can't say what the actual jury felt, but I can say that the the mock jury that comes through the chat, that's what they believed. Welcome, Vita Rivera. We've got another new member. Glad to have you. All right, we'll answer a couple more. Do you think his attorney got any sleep last night? He looked haggard, E. Steele asked me. It's often hard to sleep during trial. Not only are you so pumped up, but you're working nonstop to try to get ready for the next day. You go home and that you've just finished the first half of your day. You've still got to prepare for all the witnesses and things that are going to happen the next day. Plus, of course, there was the stress. That had to have been incredibly stressful watching that happen. Really brutal. Has the prosecution had a "we gotcha" moment? Asked Elevate the Process. I think that they believe that the deleted text messages were a gotcha moment, but I think that there were several pieces of evidence that to me were stronger, that seemed more impressive than that. The hat and the shoe in his home are huge ones. That's just an example. The photographs on his phone of the neighborhood where Gurman lived, etc. Can they triangulate his height using the camera angles and compare his gait to that of the person on the footage? They definitely had testimony comparing the gait. He has some kind of hitch, and they sort of hitch in his walk, and they said that that person did as well. I don't know if they triangulated height. I came into the case a little bit late, so I'm not definitely sure about that, but it would certainly be a good idea to do that, to try to figure out if they were about the same height, because he is a little smaller for a man, and therefore if he was at that height or pretty close, maybe that would have been helpful to the prosecution. I don't believe it's a death penalty case, Carlito. I guess I don't know that for sure, but I don't believe it is. Okay, last question from Lee T. Had the jurors asked any more questions since the unaliving attempt for sympathy question? So I'm not exactly sure what question you're referring to, but I think the very last one related to that conspiracy issue that I talked about a minute ago, about whether or not the phones, the pictures on his phone could have been airdropped to his phone without him being able to do anything about it. No action on his part. He didn't take the pictures. Someone airdropped them onto his phone. And that was the question. They asked that of the final witness of the entire trial. And he said that airdropping per se could not happen because this wasn't an Apple phone, and that's an Apple function. It's not something that a Google phone like he had would do. Now, that doesn't mean there wasn't something that was equivalent, and the jury didn't get to ask a follow-up. I bet whoever thought of that question had the follow-up. Well, is there an equivalent of that on a Google phone? Could there be a drop of pictures that someone didn't know about? Because I think it was a twofold question. Could it happen? And would there be some sign of it? Would you be able to tell that that had happened? And there wasn't a direct answer to that. All right. Well, we will be back on Monday at 7 p.m. Eastern. And we have another new member, M&M. Super glad to have you. All right. We'll be back Monday, 7 p.m. Eastern. It's a big day. We not only will have this case going to the jury, the closing arguments will happen on Monday, as well as the jury instructions. This will go to the jury. So we'll have that happening. Also next week, Corey Richens has a 3-day preliminary hearing that's going to give us the biggest insight we've had so far into the evidence against her and into what her arguments are, saying that she did not poison her husband, Eric. So we will be covering all of that next week. It's going to be a huge week. We'll probably be doing more than our usual Monday, Wednesday, and Friday at 7 p.m. Eastern. But for sure, we'll be doing Monday, Wednesday, and Friday. So I will see you next week.